Good morning. Welcome to Bar Talk, May 29th. And today, it's pretty muggy out there. You can see I'm without a jacket today. It's going to be the start, I hope, of a great weekend. We've got a great guest, Justin Andrus from the Board of Overseers. Our friend Harry McKinney from the Kennebec County Sheriff's Office sent a note to us today indicating that his contacts at all the 16 counties at sheriff's offices says civil service is starting in full service beginning Monday. So lots of opening changes. And I think I heard Justin's voice there at the beginning. Yep, there's Justin. Justin, welcome. Thanks for joining us. We missed you last Friday, and I trust all is well with you. And we'd be happy to hear from you and the Board of Overseers.
Good morning. Thank you very much. I apologize for getting detained last week. For those of you who don't know me, I am Justin Andrus. I am Assistant Bar Counsel at the Board of Overseers. Got a hit list of things that have been coming up recently. I'm not going to go into a lot of detail given the time frame, but if you have questions or concerns about any of it or anything else, please reach out to us. We've been seeing some things that are happening with the reliance on remote practice that I think are worth commenting on. There's been an increasing incidence of fraud that we have seen perpetrated against attorneys and law firms recently. Very sophisticated. A number of firms have been had a problem with it, and it relates to a person who appears to be a client engaging the firm, and then a case being settled and a check being fraudulent, and the firm being responsible for the fees, for the overdraft in the trust account. We're bringing it up now because
Justin, please tell us a little more about that, because just so you know, I may be a victim myself. I think I have a $199,000 check right here in this envelope that is with a Florida, came from Canada, and it has a Florida business asking me to cash it and get those funds to them.
So what we're seeing is, it may be that very thing. What we're seeing is that an apparent client comes in and hires a law firm to collect debt. Another person is identified as the debtor. The firm negotiates with the apparent debtor, a settlement is reached, and the debtor pays money to the firm in the form of a check. The firm deposits that to the IOLTA account. The bank makes the funds available, but eventually the check bounces and the law firm is on the hook. So a couple of things are significant. This is not an exclusive detail, but be careful where the check comes from Canada, because the Canadian check clearing practice or policy, I'm not sure where the rule comes from exactly in Canada, takes longer than most funds availability policies for banks in the United States. And so that's why these checks tend, not exclusively, but tend to look like they came from Canada. That's probably why the check you have in your hand appears to have come from Canada. There's not been a lot of this. It's happened a couple of times. But we want to make you aware of it, because in light of the inability to meet with clients or reluctance to meet with clients in person these days, it's harder to judge somebody's credibility. And also, although certainly I don't ascribe this to any particular firm, firm revenue may be somewhat sporadic at the moment, and there may be a tendency to be more interested in taking cases that might have been less interesting in the past. So just protect yourself. Make sure the checks have cleared before you disperse. Don't simply rely on the funds availability policy of your bank. And if you want to talk about that in particular, Thad, you can call me later. We can see what you got, because I know that there's been law enforcement interest in the fraud that's going on. The other thing that we're seeing is people fact bombing websites. And so this is another thing with the increased reliance on remote communications. Most websites have a "Hey, contact us" kind of form on their website. And we've seen a recent instance and some other instances of people dumping facts into a website's form in an interest of creating a conflict. And so just check out your website, make sure that you are not setting up an expectation if somebody dumps something there that they're becoming a prospective client. Read Rule 1.18 and particularly Comment 2. Comment 2 makes it so that if somebody unilaterally dumps information on you, you don't suddenly have an obligation to them, but make sure that you're protected by that when you do your website.
Now, Justin, do you have like, with regard to something like that, do you have a recommendation of like what language we could include maybe on an email? If we're responding to someone that's dumping something maybe in an email to us too, so that it's maybe automatic with what we, every time we send an email, clarifying whether or not we have a attorney-client relationship?
I don't have particular language, but I'm making a note because it might be something we could send out in one of the bar blast emails that we do. The key is that you need to communicate to the client on the website, in the form, in the email, that by responding or receiving the information, you're not necessarily willing to entertain them as a prospective client. That's the key to distinguishing a prospective client from somebody who's not a prospective client under Rule 1.18. And that's what then drives whether or not you have a conflict if you learn information that you didn't intend to learn. I see that I'm going way over my 4 minutes, so I'm going to just add one last thing and then I'll stop. As probably most of you saw in the Bar Journal, there was an article from ALPS about the increased incidence of malpractice claims during periods of economic downturn and recession, which sort of makes sense as people get hungry. I just want to remind everybody that frequently we see grievances as part of an effort to create leverage in a malpractice type situation. And so we haven't yet seen an uptick related to any kind of recessive economic activity. We want you to be aware of it, take good steps to have good client contact and file hygiene. Thank you, Angela. And if you do get a complaint, please get somebody to help you address that before you respond to us. We are here not to prosecute lawyers. We're here to ensure good conduct. We want to make sure that we don't have a client taking advantage of the situation. And I'll leave with, we're here. I see it, Thad. Go ahead.
You knew I wanted to ask a question. So what is it that the Board of Overseers does to help attorneys in this regard? So let's say someone files this grievance with the Board of Overseers, but if you really sift through what they're writing about, it's really like a fee arbitration issue. Mm-hmm. What is it that the Board of Overseers does to actively maybe redirect a person that complains like that?
So we do typically redirect people who complain about what are fundamentally fee amount issues to the Fee Arbitration Commission. We typically do that by providing a fee arbitration petition to the complaining party. There are issues related to fees that could form the basis of a grievance. But if a complaint talks about fees or dispute about fees and doesn't invoke one of the things that would actually be grievable conduct, then typically we don't pursue a grievance on that basis because it's not misconduct from our perspective. They could be related, but they're certainly not the same thing. If you have questions about a dispute with a client or anything else, please call us. We are here first and foremost to ensure that the Maine Bar practices safely, ethically, and effectively. And we would rather answer a multitude of ethics line calls and emails. I'm on the ethics line today. I'll be doing that for the rest of the day. We'd rather answer tons of those calls than prosecute a single grievance. And so if you have questions, if you have concerns, if something feels spooky, we can't solve every problem, but we certainly will do our best to help you navigate that process in a way that obviates the need for them.
Well, Justin, thank you very much, and thank you for your time. Thanks for joining us on Bar Talk. Um, and you can hang on if you want until we finish up. There might be some other questions. And with that, business side updates, Angela.
I don't really have a whole lot new to add today. I hope everybody has a great weekend. Thanks for joining us on Bar Talk. Don't forget, though, that next week we'll only be holding Bar Talk on Monday. Same time, but we might go a little bit longer than our 15 minutes. We'll be somewhere between 15 and 30 minutes, but Justice Mead will be joining us. So probably we'll end up taking a majority of that 30 minutes.
Okay, great. And I actually had a little bit I wanted to add on the business side. Some of it I've alluded to before, but I wanted to let you know that there is a movement afoot to kind of have a consensus on some changes that we want to ask the court to make an order on. And we're probably, as a MSBA organization, going to be doing that sometime early next week. In at least a couple areas, we're going to be kind of, I think, I don't know if forced is the word, but we're going to be looked at to comment on the MTLA is going to be making a request for electronic or some sort of digital type signature for documents that get filed with the court going into the future, perhaps the rest of the future, foreseeable future. We mentioned before that the judicial branch is on target for starting or launching electronic filing in Penobscot County in Q4, and that we're also being asked to comment on our position as an organization on making remote or video type depositions the norm versus not the norm. And if you've got any comments on that, or no colleagues that might have comments on that, please forward those to me or Angela so that we can represent this organization as best we can.
Dad, I have a question.
Yes.
The last I heard was that the annual report filing fee was still due to the Secretary of State's office on Monday, June 1st. I've not heard that change, but I'm wondering if anybody else has heard anything different.
Yes, if anyone else has, please speak up. I know that our office is involved in representing a number of corporations, and we haven't received anything but reminders that we need to file by June 1st. So.
And do you know if there'll be a late fee if you file late with everything that's going on?
That's at least that's what I thought I read in the reminders. But if anyone has any additional information, please chime in, because this is timely. That means Monday's our deadline for filing corporate annual reports.
I would assume they're going to charge a late filing fee if they're keeping that deadline, but yeah. I'd have to call the Secretary of State's office to actually ask that, unless somebody knows something different.
Yeah, I know that that's what they typically do.
I've got someone that would like to talk about the Canadian checks to the group, if that's okay.
Oh, all right.
Sure. Hi there, everyone. So I actually in-house at a bank right now, and I just wanted to mention that one of the reasons why the Canadian check part of this is important is because many of the local banks will make the funds available in your accounts within a day or two. However, the funds aren't actually received from the Canadian bank often for several days after that. So what they're doing is they're trying to take advantage of the fact that you're being given access to the funds before the bank actually gets them. And if the Canadian check is returned as being, something that is not supported, essentially the money comes out of your account and you're now on the hook for it. So what I would suggest for anyone who does have Canadian checks or have checks coming in that are drawn on Canadian banks, you should probably check in with your bank and find out not so much when the funds are going to be available in your account, but when the funds should actually be received by the bank. And you don't send any checks out to your supposed clients until you have confirmed that the funds have actually been received.
Yeah, that's great advice, Daniel. Thank you.
May I hop in there for a second?
Yes, Justin.
So that is great advice, and not just great advice with Canadian checks. That can happen with insurance drafts, that can happen with different kinds of checks. Before you write a check out of your trust account, it would be the correct practice to make sure the money is really there and really available. Because you will be responsible for that problem. It is unlikely the bank's going to accept any responsibility, and most insurance companies do not see this as an insured loss.
Yeah, that makes sense, Justin. I've been in that habit of doing just that for years now, just because I deal with real estate closings too, and got a check that comes in. You want to make sure that before you cut a check to the other parties that it clears. Any other thoughts on that? Before we're pretty much out of time, we're wrapping up. I just wanted to, on the personal side, say thank you, do a shout out to our police, especially the ones here in Maine, but those all around that are doing the best job they can to keep us safe. I'll see everyone on Monday, 11 o'clock.
Thanks, Justin.
Sure thing. Happy to do it. Have a great day, guys.
Have a great weekend, everybody.